Okay, well, welcome everybody. We are going to get started here. Thank you so much for tuning in to the California Lawyers Association Privacy Law Section's interview with Jennifer Urban, who is the chair of the board of the brand new California Privacy Protection Agency. For those of you who don't know, the California Lawyers Association is the bar association for California lawyers, and the privacy law section, we're focused on privacy lawyers. We are so excited to get to sit down virtually, albeit, with Ms. Urban and talk about the formation of really this historic event, the first privacy-focused agency in the United States. So all eyes are on us. Just to briefly introduce Ms. Urban, she's obviously so well accomplished. She is, since 2009, she's been the clinical professor of law and director of policy initiatives for the Samuelson Law, Technology, and Public Policy Clinic at the University of California, Berkeley School of Law. And before that, she was at USC Gould School of Law, Stanford School of Law, and also worked at the Venture Law Group. She was appointed earlier this year to serve as the chair of the agency by Governor Newsom, and not surprisingly, she's taken a sabbatical from her work at Berkeley, because as you will see, there is a lot to do. Ms. Urban leads the 5-member board we'll hear more about. And just yesterday, the agency announced the selection of its first executive director, Ashkan Sultani. So movement is ahead. So in this interview or fireside chat, I just want to outline what we'll be doing. First, we're just going to set the table. We're going to give you a high-level overview of the agency, its mission, and its structure and staffing. Next, we're going to get to the issue most privacy lawyers want to know about most, which is the rulemaking. What's happening? What are the timelines? What? So that'll be the second piece. And then at the end, we will take questions. So you can submit the questions in the Q&A. Jiwan Serrato, who is also on screen and the former, just recently, recently her term ended, but the founding chair of the privacy law section, she will be filtering through the questions and pick out a couple to ask at the end. We'll reserve about 10 minutes for questions. If you have a procedural question, we may be able to answer those, but the questions from Ms. Urban we will reserve till the end. And finally, you should know that we are recording this session, so full disclosure. Okay, so let's jump right into setting the table, as they say, and a high-level overview of the agency. So Ms. Urban, for those of our listeners who may not know that much, can you just tell us what is the California Privacy Protection Agency? And most importantly, what's the proper acronym to use?
Thank you. First of all, I just want to say how delighted I am to be here, and thank you to both you, Sheri and Jiwan, for having me. I'm a proud member of the privacy law section, so I'm particularly excited to be here today and to talk to California lawyers focused on privacy about the new agency. For anyone who hasn't followed it closely or hasn't waded through the entire CCPA and its amendment, the CPRA, which I know is a job, the California Privacy Protection Agency was created by the California Privacy Rights Act, Proposition 24, in November. So it's actually something that was instituted by the people of California through a proposition. It is the first agency with administrative powers focused on privacy in the United States. As I know the audience is well aware, there are data protection authorities in Europe and in South America, lots of other places in the world. But in the United States, this will be the first agency that is focused on consumer privacy specifically. The agency has a fairly broad mandate with some specific responsibilities and requirements. Its underlying purpose, the law is very clear about its underlying purpose. It's charged with protecting the fundamental privacy rights of natural persons with respect to the use of their personal information by implementing the CCPA. And the agency is also instructed that the law is to be implemented with the goal of strengthening consumer privacy while giving attention to the impact on business and innovation. So we have a pretty clear mission statement, if you want to call it that, or sort of guidepost for how we should structure our work. And then in terms of the work, as I said, it's fairly broad. So the CPRA empowers and directs the agency to engage in rulemaking, enforcement, public awareness, providing guidance to businesses, providing guidance to consumers, and a number of other activities like advising the legislature if they have privacy questions, and monitoring developments in business models, telecommunications technologies, and that kind of thing in order to keep abreast of privacy issues as business models and technologies develop. We will be sharing enforcement authority with the Attorney General. So many people who are here today, of course, I'm sure are very familiar with the Attorney General's enforcement responsibilities under the CCPA as it exists now. Once we get down the line to the point at which the agency takes on some enforcement authority, the agency will have administrative enforcement authority. And that means there will be an administrative process for enforcing the law, and the AG will continue to have civil authority. So the AG may choose to take someone to court, and that's within their prerogative to do, whereas the agency has the administrative authority. So we will be doing collaborative enforcement with the AG.
Great, thank you so much. That's very helpful. All right, well, let's just talk next about the staffing and structure of the agency, starting with you and your board. So there's a 5-person board, and we've included in the chat a link if you want to see exactly who is on the board. But why don't you just briefly talk about who is on the board and what role they play and will play specifically with rulemaking. I think we're all really focused on the rulemaking process.
Which is a good place to focus. That's the first thing out the gate for the agency. It's a 5-member board. All of this is set out in the CPRA, appointed by a range of authorities in California. The governor appoints the chair, that's me, and one other person, Chris Thompson, who he's the other gubernatorial appointee. The president pro tem of the Senate appoints one board member. The president pro tem has appointed Lydia De La Torre, whom I'm sure plenty of people in the meeting know because she's a highly skilled California data protection lawyer. The Speaker of the Assembly appoints one member. The Speaker has appointed Vincent Lay, who is a privacy and civil liberties focused lawyer who works at the Greenlining Institute. And finally, the Attorney General appoints one member, and the Attorney General has appointed Angela Sierra, who used to head up their consumer division, and she's now retired from the AG's office. So that's the group that is the inaugural board of the agency. The agency is independent. So it isn't under the administration, for example. It's independent or quasi-independent agency. The authority granted to the agency in the law is held collectively by the board. The board can delegate authority to the chair or the executive director. And so I've been operating under a delegation of authority to do things like hire and make agreements with the Department of General Services for HR services and finance services and that kind of thing. And some of that obviously we will delegate to the executive director, which is a common practice with state agencies. However, there are 2 things that the board cannot delegate, which are rulemaking and enforcement. So final decisions on rulemaking and enforcement have to remain collectively with the board.
Okay, you anticipated my next question, which was the role of the executive director vis-a-vis the board with respect to rulemaking. How are you envisioning that interplay? I understand the board has ultimate authority, but have you given any thought to what that might look like?
So let's start with the usual practice, and then we can talk about the practice with a brand new agency still being born. So the usual practice, and I'm sure many people here are aware, they've probably participated in various rulemakings by state agencies. The staff under the purview of the executive director, the general counsel often under the executive director will engage in the rulemaking process. They'll prepare the regulations, and the board makes the decisions to, for example, go out with the regulations with the initial statement of reasons and the notice, and makes the decision to adopt the regulations and send them to the Office of Administrative Law for approval. In our situation, we are building the agency while we need to do rulemaking, and that it does not, I wouldn't say it complicates things exactly, but it does mean that board members are a little bit more directly involved in some of that initial work than we probably otherwise would be. So we are working to hire staff quickly. We're really happy to have our executive director. We're working on doing some hiring that is a little bit quicker. So for example, retired annuitant attorneys who've retired from state service but can come back part-time. So we are exploring that as an option, as well as hiring and looking at other options as well. But we also understand that board members will need to be doing some substantive thinking work at the least. And that isn't, I should say, that isn't in any way unheard of. There are other boards that operate this way. They're fairly lightly staffed and they have experts on the board, so they will operate this way. And for those of you who are in our September 7th and 8th meeting, you will have seen the way that the board has structured our work at the moment. But for those of you who were not in that meeting, we have split into 3 rulemaking subcommittees, each of which is responsible for a different part of the subject matter. And we can talk about why we need to do it that way whenever it's convenient, Sheri. It has to do with the open meeting laws. But those teams will be working with lawyers as we're able to bring them on to process the public comment and work on turning those into regulations. The board will then need to consider whatever the subcommittees and staff come up with before it goes out into the formal rulemaking process.
Okay, and I know you have some slides to show about that, and we can pick those up in a second. Just to close the door on the staffing of the agency. So if now that you've hired an executive director, does that mean the gates are open and folks can start applying to be a staff attorney, or how does that work?
I hope people will apply, as lots of people will apply. We would love to welcome many California attorneys into the agency. What people who are interested in applying should do is keep an eye out on our website for job postings as they go up. Most of the attorney positions will be civil service positions. And so there's a process for that that we are working through, and we'll be posting those as we have them. We should be posting a general counsel position quite soon. This position is what's called a career executive assignment. It's a high level state executive position, and that requires a sort of extra layer at the upfront extra layer, various approvals from CalHR and the Department of Finance, and then the position actually has to be posted for public comment for 30 days. So that has all happened, and we're just getting our final approvals in place from our control authorities, and then that will be posted. So definitely keep an eye out for that. I would ask people to do. And also, if you're not interested yourself, I'll just ask, and if you wouldn't mind amplifying when you do post these, let people know who might be interested.
Okay.
And for folks who are interested in future positions, they should feel free to reach out and let us know, so that we are aware that there's interest there, and can be sure to send job postings when we have them.
Terrific. Okay. I'm going to touch on two things, and then we'll dive into the nitty-gritty of the rulemaking process. Go ahead.
I was thinking about the structure of the agency, and I can't believe I did this because I've been a professor for years and I know better. I need to do my disclaimer, which is quite important, because the board holds power collectively. And although I've been delegated authority for day-to-day things, I just want to be very clear that I can't speak for the board or the agency. I'm only speaking for myself. However, I can refer back to things that we have collectively decided or discussed in public meetings, and I'll try to highlight that if that's what I'm doing. But just to be clear, I'm only speaking for myself. And I'll also, every once in a while, I might say, this is just me. I'm one board member, I'm one vote. And this is what I think. But I can't speak for the agency collectively.
Understood. Thank you for clarifying. Just so two brief things. One is you mentioned the open meeting laws, and I think that's a very unique feature of the rulemaking process that was not a feature of CCPA rulemaking. So I know there's much to say about it, but maybe at a very high level, if you wouldn't mind explaining what that is and the impact it has on how the board and maybe the agency is able to operate in terms of rulemaking.
Sure. So our board operates under the Bagley-Keene Open Meeting Act, which is true of all boards and commissions in the state of California. The equivalent for city councils and other elected entities like city councils is the Brown Act, which a number of people may be familiar with. There are very strict open meeting and open deliberation requirements under Bagley-Keene and the Brown Act in the state of California. The people have made a purposeful decision to sacrifice efficiency for transparency. So there's a very, very important public value behind the way the Bagley-Keene Open Meeting Act works. In practical terms, it absolutely makes things a lot slower, and it's making things a lot slower in our particular situation because we are building the agency while we're working on substantive work. And the reason why is because board members cannot deliberate outside of a public meeting. And what that means in practical terms is that we can't talk to each other. So we met for the very first time on Zoom on June 14th for our first meeting. That was absolutely the first time that we had met outside of, hi, how are you? This is my name. So, you can kind of talk about very social thing. I have 2 kids, and you can talk about logistics, like, can you make a meeting on this date? But we cannot deliberate with a quorum. So that would be 3 people. And because it's easy to maybe talk about a topic accidentally with more than one person, in practice, we are very limited in our interactions with each other. So that means that we can't tee things up in advance of a public meeting often. We just have to get to the agenda item and talk it through. It also means that we can't sort of collaborate behind the scenes to get work done, except in certain ways. So there's one very important exception, which is the subcommittee allowance. So we can have up to 2 members on a subcommittee. The subcommittee of the board can serve in an advisory capacity. Subcommittees aren't able to have decision-making capacity. The board can't delegate authority to a subcommittee, but subcommittees of 2 people can do work and then bring that to the public meeting. So that's important, and that's why we have 3 subject matter subcommittees working on the rulemaking. Lydia De La Torre and I were the original regulations subcommittee who worked out that plan, which the board agreed with. We could advise the board that we thought this was a good idea, and then the board agreed with it, and we've now split into these 3 subject matter subcommittees. So that allows for some substantive work to be done by board members, but in general, it's quite limited.
Okay, well, I think I'm just going to skip ahead and just jump right into rulemaking because we're there. I'll save the other question for later. So let's talk about rulemaking. So most of us are familiar with the process for CCPA. There was preliminary rulemaking activities, then more formal rulemaking activities. And so I think you have a slide. Maybe you can just show us what for the agency timelines, where we are in the process, and then we can dig into the subcommittees a little more.
Sure. So let me bring that up. One second. Zoom has decided it doesn't want to see that program, so hold on.
Oh, okay. Well, we can just, if
it's too, okay. Probably just need to try again.
Okay.
Here we go.
Okay.
So these are the subcommittees, but we can go back to that in a moment.
Okay. Yeah, I think that little graphic we're all familiar with it, but the gray boxes we haven't seen before. So, or those of us who hadn't attended the board meeting.
Yes.
Okay. So yeah, just where are we? What's the process? Where are we? And what are you thinking in terms of realistic deadlines or deadlines?
Wonderful, thank you. So first of all, the CPRA has in place a number of deadlines and dates. The first is that the agency needs to give notice to the Attorney General that it will accept rulemaking authority or that will take on rulemaking authority. Once we send that, 6 months later, the rulemaking authority will transfer. So we'll need to be working on that pretty soon because the initial rulemaking package under the CPRA is meant to be finished on July 1st of next year. So July 1st, 2022. And then takes effect January 1st, 2023. And then enforcement follows after that, July 1st, 2023. So those are the basic deadlines set out in the statute. What we have, and I'm sure folks are pretty familiar, as you alluded to, Sheri, with this graphic from the Office of Administrative Law of the California rulemaking process under the Administrative Procedures Act in California, which is a very strict series of actions that have to be taken by an agency. But we can do preliminary rulemaking work, gathering information, taking comments that we can structure in sort of any number of ways before we get into the formal rulemaking. So what we've done already is create the subject matter subcommittees and started some pre-rulemaking activities. And my own hope is that we are able to gather a lot of useful information through pre-rulemaking activities because that makes things a lot more efficient. It helps us be responsive to comment as the rules are being written, rather than having to write the rules and then see that we didn't understand something, and then respond to comments. So I'm hoping that we'll get a lot of information that way. We've already released an invitation for comments. If you're more familiar with the federal process, it's often called a request for information. But in California, we usually call it an invitation for comments. And that is up on our website. And I believe will be sent around to the section if you haven't seen it yet. With a series of structured questions drawn from the things the CPRA asks us to regulate on, but an invitation to comment on anything under our authority. It's not in any way exclusive. We are simultaneously, as I mentioned, working on hiring personnel. And then one thing that is not actually on this slide, but that we are hoping to put together in the next two to 3 months are informational hearings, public fora that, again, they're just part of the preliminary process in which we can have a conversation and hear from stakeholders in advance of the formal rulemaking process. Once we have information in place and draft regulations are created, then we can go out with the formal rulemaking process. So in the winter, and this would be pretty early winter, January or February, we would publish the initial notice and what's called an initial statement of reasons along with the text of the regulations. That kicks off the APA process. There's a 45-day required process for comments, and we anticipate holding public hearings. We need to hold at least one, but we'll see how many are needed. And then once all of that information is in, the agency responds to all the comments, makes decisions about how to reflect them in the regulations or why the comment maybe won't be reflected in the regulations, after which the package is voted on and submitted to the Office of Administrative Law for review and approval. So that's the sort of basic timeline.
And what is the date, if you're working backwards, what's your deadline by which to submit it to the Office of Administrative Law in order to give them enough time to make the July deadline?
They need 30 days. In practice, it's sort of mid-May.
Okay. Okay, mid-May then. And I think that, so it seems a bit aggressive. I think to those of us watching, what happens if you can't make the deadline? What are the options? I have to imagine you're already thinking of them.
So we did talk about this some in the September 7th and 8th board meeting. It is an aggressive deadline. It's a particularly aggressive given that we are creating the agency at the same time. But for folks who were involved in the CCPA process, that took a couple of years. These are complex regulations with a lot of stakeholders. And we are aware that there's a lot of work to be done. There are a variety of options. The legislature could extend the deadline. The legislature could declare that the regulations are emergency regulations, which is a little bit technical. But what that means in practice is that there's more time for gathering information, doing more preliminary work. The Office of Administrative Law has a streamlined process for emergency regulations, and they go into effect on a temporary basis. There's a short opportunity for comment. It's just a few days in case there's a showstopper. The regulations go into effect temporarily, and while they are temporarily in effect, then the whole rest of the process continues. So it's not as though it changes the need for formal public comment. It just changes the timeline and the order a little bit in order to allow for the regulations to come out. So that is an option. There's also the option of just saying, we aren't going to make this deadline, and here's what we're planning to do about it. So, for example, extending when we might begin enforcing, so people have time, that they have time. It takes into account the delay so that people have time to understand and implement the regulations. So those are some options we talked about. There may be others, and we will actively receive counsel about what various options would be. But at the same time, we're just moving full steam ahead.
Yeah, no, understandably, as you have to. So just a clarification. So just to make sure I understand, on the emergency regulation, the concept there is an agency issues regulations without the full notice and comment process having concluded. And those are in effect temporarily until that notice and comment process concludes. Did I get that right?
Well, I wasn't specific about, they're in effect for 6 months. It's actually, there's a set period of time. And you continue with the formal rulemaking process at that time. They will expire if they need to, but the idea is that by then you've done the full robust. It's a very robust process in California, formal rulemaking process, and then you can issue the final regulations.
Okay.
Either way. And this again, this is me speaking, but I know other board members expressed this in our meeting as well. We do understand that if we are thinking about the timeline changing, that we need to think about the timeline on the back end too. What does that mean for people who need to comply, businesses who need to comply? What does it mean for consumers who are looking for tools to exercise their rights? We need to be sure that we are taking all of that into account if it turns out that the timelines change.
That's very helpful, and I'm sure everybody's appreciative of hearing that you're aware of the impact. In that vein, does the agency have to go to the legislature at all to be able to pursue any of these paths?
If we were to have the deadline formally extended, either as an emergency, to change it to the process to an emergency rulemaking, or to formally extend it, yes, then the legislature would have to agree.
Okay, so the agency can't on its own extend rulemaking. Is that fair to say?
The agency can't change the deadline in the statute. If you may recall, the regulations the Attorney General adopted did slip by like a couple of months, and so that is something that sometimes happens. But if we were to formally change the deadlines in the law, we would need to ask the legislature to do that. Okay.
All right. And, I'm just going to slip in my other comment here. My other question I didn't ask earlier, which was, I don't know I think it's quite unique to have an agency created by initiative. And the question is, does that confer any unique powers on an agency that's created that way with respect to rulemaking or even enforcement at any step of the process? Does it matter?
Well, it is unusual. The Fair Political Practices Commission, as I understand it, was created by initiative in the 1970s. There may be other examples. Let's see, redistricting. That may have been an initiative. I think it might have been an initiative. We have a redistricting commission that is a nonpartisan redistricting process in California. So it's not unprecedented, but it is unusual. It doesn't happen that often. In terms of whether it changes things, the agency's power comes directly from the people. And so there are possibly some things that affects, like the people are able to declare that they would like an agency to do various things that perhaps the legislature would be more limited. But I don't know, I have to say, I'm not sure what details there might be in our particular law that would look like that. It doesn't change, the timelines, or basically, the law tells us what we have authority to regulate, and we have to follow those strictures.
Okay, all right. All right, well, let's jump into the subcommittees, just because you've been talking about them so much. Everybody's anxious to see them, I'm sure. So let's just see what those subcommittees are, if you want to pull up that slide, if it's easy for you to do so.
Sure.
And maybe you can, and then if you can just describe, so these are as I understand it, these are the subcommittees of the board. Mm-hmm. And so just describe for us what these are and who can participate in these subcommittees, and what's the work product that's supposed to come out of these subcommittees.
Okay, so these are the three subcommittees. Under Bagley-King, we've divided ourselves up into subject matter silos that some things can't be disaggregated, so we couldn't put them in in separate subcommittees. And we're organized as follows. Things that are completely new with the CPRA. As these are sort of rough descriptions, again, because sometimes we couldn't completely disaggregate, so we had to keep a couple of things, for example, in the update subcommittee for that reason. But so the new rules subcommittee has started out looking at the agency's Audit Authority, which is a new authority in the CPRA, the cybersecurity audits that businesses who are working with particularly risky data practices or information will need to do, the risk assessments that sort of not exactly the same, but another responsibility, and automated decision making. So that's where they've started, and I'll explain why they may have more in the future. The update subcommittee, that is, and that is Vincent Lay and Lydia De La Torre. Those are the members on that subcommittee. The update subcommittee, that is Angela, Sierra, and myself. And we're responsible for a set of topics that relate to or are updating the existing regulations in line with the CPRA. So for example, any updates that need to happen with opt-out requests, that's in our subcommittee. That includes the opt-out preference signal, which is what the CPRA calls it, and the new right to correct. Our job, is one of our jobs to think about how the right to correct should interact with the existing rights to erase and right to know, process-wise, and some various definitions of personal information, including updating for sensitive personal information, things that have changed in the CPRA, but that touch existing regulations. That's the sort of animating principle behind our subcommittee. And then the final subcommittee is the process subcommittee. That is Lydia De La Torre and Chris Thompson. So they are responsible for process as it sounds. They're coordinating the informational hearings, collecting our comments that are coming in, thinking through the timeline and refining that sort of thing. And then they also have a long list of topics that we understand to be things we could put into the regulations, or we could wait or not. So maybe they depend on whether or not there's a technological need for it, like geolocation, dark patterns, that kind of thing. And so they are looking through all of those topics, and then their job is to come to board meetings and say, hey, update subcommittee, or hey, new rules subcommittee, you should add these topics to your portfolio. So those are the three subcommittees. You asked earlier about working with staff. And I realized when I was talking about Bagley-Keene, I skipped over that. So staff can coordinate and work, of course, on things, and they can work with all of the subcommittees. They just can't serve as a hub between them. So they can't transfer information from one to the other board members, but they themselves can work with all the subcommittees.
And are the subcommittees able to meet informally with, I can't help but notice that the executive director is a big proponent of the global privacy control, for example, that falls within your subcommittee. Would he be, maybe that's a bad example because he's within the agency now, but before he was, could he conceivably meet with your subcommittee and talk about the global privacy control, for example? I'm not asking you if he has, or I'm just using that as an example.
Conceivably. I mean, the other thing is the public can talk with board members. It's on board members to be sure that we're policing ourselves and making sure that we're not accidentally leaking information outside of the strictures of Bagley-Keene. And in any case, one of the reasons why I wanted to explain this was because I wanted people to understand kind of who's initially in charge, which is not to say that you can't talk to other board members, because we all will have to review the work product eventually. But these are the people who are initially in charge. So In theory, yes. I don't know, of course, what the process subcommittee is prioritizing. But one question to ask them would be like, will we have a kind of a path for that? Of course, we're certainly putting in place more formal paths, the invitation for comments and the hearings. So people should absolutely keep an eye out for that. But in theory, we can talk with people as well.
Okay, that's very helpful. All right. And so just, I know you touched on this earlier, but what's the work product that will leave each subcommittee? What's the goal? What's the work product that we can expect to see from each subcommittee?
Eventually, each subcommittee will most likely be responsible for bringing their chunk of draft regulation to the board. For our next meeting, before Lydia and my subcommittee dissolved, we asked everyone, obviously people have to do a lot of substantive thinking, information gathering and work, but for our next board meeting, we've asked subcommittees to bring topics for the informational hearings that are within their ambit so that the process subcommittee can work on that. So that's one initial thing. And then eventually the subcommittees will presumably make recommendations about the substance.
Okay, and then you touched on drafting, and I just wanted to know who is going to be actually drafting? Is somebody already starting to like make a shell or put pen to paper for these regulations? It sounded like it would be happening simultaneously when you talked about it earlier.
Between the subcommittees?
Or just the drafting of them. Is that gonna, you said it's not gonna start once all the comments are in.
Well, we are doing, right now we're doing preliminary information gathering. So that's the current, that's what we are currently doing. I can't really speak to decisions that will be made in the future.
Okay. And then I know that the CPRA contemplates that the AG's office could be involved in rulemaking. What role, if any, are they playing or have they played in the rulemaking process?
So they did their package of regulations. The agency is now doing the second package of regulations. I do understand that there was some curiosity about that. I mean, until the authority transfers, in theory, the Attorney General's office could have started doing the rulemaking, but it's the agency that's doing the rulemaking. The Attorney General's office, we've requested some support from them formally, and I should have an update on that, I hope, by our next board meeting.
And when is the next board meeting?
It's October 18th.
Okay, great. And you don't have to give 30 days notice for those board meetings, do you? What is the notice requirement?
10 days notice. So the notice will be coming around on Friday.
Okay, and so if people want to keep abreast on those meetings, what's the best way for them to do that, to get notice?
They should sign up for our mailing list. If you go to cppa.ca.gov, you can click on the regulations page, you can click on board meetings, which is right on the front page, you will get to the mailing list page, and you can sign up for the mailing list to be notified of board meetings and other things. For example, we sent around the announcement about our executive director yesterday to that list, and then you can also sign up for the regulations, the rulemakings list, so that you're getting any notices related to the rulemakings.
Okay, terrific. All right, and one of the notices I am signed up and that I received was the invitation for preliminary comments. We have a link to it in the chat. It's a 5-page list of topics that you all have identified with a lot of hard work, gone through the monster that is CPRA and teased out all, a number of topics that are that need regulations. What was the process that you undertook to actually highlight the particular topics that are in that list?
So the invitation for comments was prepared by the initial regulations subcommittee. That was Lydia and myself. It sort of goes in hand with the way that we split topics into the subcommittees. And yes, we read the CPRA umpteen times. We chose to highlight in the invitation for comments things that are either obviously new in the CPRA or clearly changing. But I want to be very clear that it's non-exclusive. We did try to be clear about that in a couple of places, but just in case there's any avoidance of doubt, it is non-exclusive. No one should read into what we chose to highlight or how we phrased anything to be predetermining anything. If it seems like we're sending a message, that was inadvertent. We really just went through and chose things that we knew to be new. And the reason we did it that way was because there's a lot that possibly could be covered, and it would have been an unwieldy and really, really long invitation for comments if we had asked about every single possible, should we do something on this? Should we do something on that? So we did have to curate a little bit, but we welcome comments on anything under our authority, and that'll be helpful. If we didn't highlight something and commenters think that it's important, I think it's particularly important to let us know about that.
Okay, that's very useful, very helpful. I am mindful of the time, so I'm going to zip through a couple of closing questions, and then we can go to our audience questions. So November 8th is the deadline that's in the notice to receive preliminary comments. Once that date passes, will you still be accepting preliminary comments from people?
We will not, in order to just have a clear line and to have everybody in the same position. However, if people feel they need an extension, they should let us know. And I'm sure the board would consider that in its next meeting.
And the public forums, do you anticipate those will be done by November 8th as well?
No, I don't. No, those will be ongoing, as I understand it.
Okay, and I guess I'm just going to end right here by asking you, and before we take our questions, if there's anything you could tell the privacy bar about CPRA, about the agency, what would that be?
The number, I as you alluded to, others as well, I have rulemaking on my mind. So I really encourage everyone to please take some time and respond to the invitation for comments. It will be especially helpful for us if you give us concrete examples and evidence and guidance, and if you have language to suggest, that's very welcome. So that would be my ask. And then just in general terms, I am beyond delighted and honored to be in this position, and I'm really looking forward to continuing to work with the privacy bar in California to make sure that we have clear rules of the road, and that we understand what the stakes are and how everything's going to work.
Terrific. Well, thank you so much for your selfless participation in this process. I just can't even imagine how much time you're spending on it. And just, as a Californian, I very much appreciate it. And we're so appreciative that you chose to speak with the privacy law section today. As I said at the beginning, I'm going to turn it over to Juan Serrato, who has a couple of questions from the audience. And let's see what those are.
Wonderful.
Juan, you are on mute.
The nature of Zoom.
No. I can't see the questions. So let's see. All right, well, we can't hear her, but she could always, oh, it looks like we can probably hear you now. Do you want to try? Nope, doesn't work, Shoot. Well, do you want to?
Could you paste them into the chat for the host and panelists, and I could just take a look?
That would be better.
So you can't hear me now?
Oh, yeah. We can hear you right now.
Oh, there we go. All right. So following up on a couple of points that you have made, Chairperson, you had said that there might be some legislative action that are necessary if the regulations deadline need to be pushed. And you mentioned that if you are to push out the regulations deadline, that you are cognizant of the fact that the enforcement date might also, and the compliance date also might need to push out. If that were to happen, would that take legislative action to push out the enforcement date from the CPPA board perspective, or can the enforcement date be pushed out without legislative action?
Oh, that's a great question. So again, I can't answer. This is not something we've discussed in this level of detail in a public meeting. So I can give you my sort of take on it. If we were to change the formal deadline in the statute, then we would need to ask the legislature to do a package that took all of that into account and change the statute across the board, including the enforcement deadlines. However, the agency, as I understand it, has discretion with regard to enforcement. So in practical terms, I'm not sure that we would need to change that date.
Okay, that sounds good. We have another question. Do you expect, so I think we heard that the notice of proposed rulemaking is going to begin in maybe January. It sounds like that is kind of the initial goal, with the draft rules to be sent to OAL by May. If we were to have the substantive rules by July, which is the initial deadline, do you expect those rules to be modified over time after the initial rule?
That's a hard question to answer just because it is so speculative. What I can say is that the CPRA does anticipate that particularly some topics, like I think I mentioned geolocation, for example, might need to be updated over time. There are a number of places in the law where it says, the agency should keep an eye on technological change and update them. So it is entirely possible. Speaking only for myself, again, my view is that what we will need to do is to balance certainty with taking into account the landscape as it exists for businesses and for consumers at any given time. So my hope, my own personal hope, would be that we would be able to come up with rules that provide some certainty that would last, at least until there's some seismic change, or a change that we need to reflect. But it's a little hard to predict exactly with specificity because we're still obviously working on everything.
Okay. Another point that you have made is that the board is available to meet. So you did discuss at length the kind of open meetings rule and how the board members have to meet in a group and deliberate in public. But if, let's say, a person or a company, a business would like to meet with the board, you are available to meet. Is that open meeting rule in terms of not having deliberations outside the public meetings? Does that apply to the executive director or to the staff as well? Meaning, would the executive director be able to meet separately from the board? Let's say if there were persons that were interested in providing comments outside of the public meeting?
Yes. Yes, so that is theoretical. In terms of practicality, please stay tuned to see what might be possible. We just brought Mr. Sultani on yesterday, so let him get his bearings and find his feet a little bit. And so we can figure out what is a reasonable capacity, and that making sure that we're able to hear from all constituencies and be able to manage it. So I will plug once again the invitation for comments, because that is definitely a good way to comment. But hopefully over time stay tuned to hear kind of how you might be able to have conversations with people.
Okay, I think we might have time for maybe 2 more questions. We talked about a little bit of the timeline in terms of your invitation for comment, which closes November 8th, and the notice, the formal rulemaking beginning perhaps in kind of early winter, January timeline. What kinds of companies or what kind of persons do you think should submit a comment? Why should we, give us a plug, why should we participate in that initial rulemaking and even before we see the draft rules?
Everyone should participate, and by everyone I mean all Californians whose data is at stake. So I would hope that civil society organizations, and that doesn't just mean organizations focused on privacy, any organization working for the interests of Californians, I hope would participate. I hope individual Californians will be willing to participate, and businesses across the board. So of course the CCPA doesn't apply to every business. There are thresholds, but it does apply to a lot of businesses. It doesn't apply just to online businesses. And in addition, one of the new things in the CPRA is that the agency will need to put together a certification process for any businesses who actually don't fall under the law, but would like to certify that they have appropriate practices for marketing, or just to communicate with their customers. So all of those groups, and probably more I'm leaving out, have an interest. Why take the time and make the effort to participate in the preliminary stage? Because this is the foundation upon which we will build the regulatory language. This is a very good opportunity to let us know what you are thinking, what will work, what might not work, in advance of the regulatory language being released.
I think we have one last question, and we are going to close. Do you expect that reducing operational cost of compliance will be important in the rulemaking, such as the economic cost analysis will be important evidence to present in the comments?
We will need to do an economic analysis that is required under rulemaking, so we certainly welcome information about that.
Terrific. Well, thank you. Okay, thank you again so much, Ms. Urban. We really appreciate you taking the time. And on behalf of the California Lawyers Association Privacy Section, thank you to all of you for tuning in. And this was recorded, and we will make links available on our website, on the California Lawyers Association's website as well. So thank you so much.
Thank you so much.
Bye-bye.